So, welcome to our roundtable for the month of August of 2022. And the topic that we chose today this time is an overview of domestic violence. So, across the world, we are aware that around 730 million women have reported their experience in some form of violence. And most of these people are usually in the lower middle income countries, and these countries are disproportionately affected. So when COVID-19 happened, it was actually domestic violence was actually called a shadow pandemic by certain scholars because there was a 30% increase in the violence that took place. And this increase in violence is probably due to the heightened stress and the loss of livelihood and the disruption of social and protective networks and the restricted movement, which has aggravated the issue at hand. And furthermore, as per the National Crime Records Bureau, or and as per the 2019 reports, the majority of crimes against women, which is at 30.9%, was filed under Section 498A of the Indian Penal Code, which is for cruelty by husband and his relatives. So we can see that this is a very prevalent issue in our country and it needs to be dealt with. And before we come to solutions or before we come to how we think we can deal with it, we need to understand it. So I would like to start off with the first question. How do you think that the jurisprudence revolving around um, domestic violence has grown or changed over the period of time? Who would like to start off this conversation?
Can I?
Yeah, go for it.
So, as we all know, domestic violence, like patriarchy, has been a part of our society for a very long time. And this has been seen as like, in spite of different cultures happening geographically in different timelines and things, patriarchy has been one of the common thread lines that happened everywhere. Uh, Following patriarchy, because of the prevalency of this patriarchy, domestic violence wasn't recognized as an essential aspect of uh, women or violence against women or as a public violence for a long time. So in many jurisprudence like UK, US, and for that matter, many so-called developed countries never recognized it until late 1900s. With respect to India, our first official recognition of domestic violence was through 498A. There were other sections, general sections of violence for like murder and things like that. But particularly for women, we were firstly recognized through 498A, which is basically cruelty against women, which was brought up in 1983. After this, we had a Domestic Violence Act of 2005, which was a much more broader and prevalent uh, act that helped us with these things. So they were majorly like 498A dealt only merely with the act of violence. So only if there is an active act of violence, you can recognize it under 498A. Like mere act of asking for dowries, all these subtle acts or like passive acts were not recognized in that 498A. Whereas 2005 Act actively recognized many other, how to say, passive actions like asking for dowry, intimately giving mental agony, all these things into the violence, scope of violence. So basically, like the Domestic Violence Act was based on, like rooted from the India's obligation, international obligation taken up by India from United States Committee on CEDAW. We signed a treaty on CEDAW on 1992, and we had developed this particular protection of women against domestic violence act in 2005 based on that. So with respect to jurisprudence, there were several cases, and one of the major landmark case, which though this was how to say generally known, this was properly codified in uh, Bratiban Bipin Bhai Tamboli versus State of Gujarat, which observed that there are four types of domestic violence that might happen that comes under the scope of DV Act. So one type was sexual violence, second was physical violence, and mental and economical. Though this was generally prevalent in previous jurisprudence, they codified properly this only through this case. It was in 2018. So starting from the first jurisprudential aspect, we start with there were several cases, but I note down majorly the landmark cases which explained the legal nuances that was required or elaboration that was required in that. So, Inder Raj Malik versus Sunita Malik was the first case, which, as I told, DV Act came only in 2005. So, this particular case was related to Section 498A. The section was brought up in 1983, and this case was in 1986. So, the issue dealt here was does there was another act called Dowry Prohibition Act, which was 1961. Sorry, I forgot to mention about it. So the primary question here was someone's hand is up. Parth, do you want to contribute something? I didn't see it. Sorry.
No, I think finish your point, Arvind, and then Path can continue on.
Okay, sure. No, I thought there was some doubt or something. Okay. So as of Inderpal Malik, the issue was that whether Section 498 and 48A and Section 4 of Dowry Prohibition Act come under double jeopardy because they are very similar offenses. So this way is a double jeopardy and in violation of Article 20 subsection 2. The court held no, as I previously said, the court rightly made a distinction by saying that Section 498A deals with an active act of cruelty, whereas Dowry Prohibition Act held with passive act like such as asking for dowry and things like that. It prohibited and punished passive acts like this. And coming to the second case, next we come to 2011. It was Sandhya Vakinde versus Manoj Bhimrao Vakinde. And this case also was on a similar lines with Hirlal P. Harsora versus Kusum Narottam Das, which was in 2016. Which the issue essentially in this case was whether females can be liable under domestic violence. This was basically there are two major elements of domestic violence. One should be because the term domestic is there, the respondent and the petitioners should have been in a domestic shared household. So they'll have to prove that they were in a shared household. And second thing, the act of violence of all any one of the four kinds should be proved. So these are the basic elements. And whether the respondents can be women was the point of contention here. The court addressed that in this case, particularly, the Supreme Court essentially noted that the term respondent mentioned in section 2Q is not limited to an adult male person. There, using the mischief rule, they interpreted the same as any person who acts against the woman in this case. So it can include the in-laws and women basically. And whereas they also noted that the whereas the petitioners can also include not only women but also non-adults. So children can also come under. So they basically clarified both petitioners and respondents in this case.
Yeah.
So they clarified. Supreme Court clarified that the women and non-adults are among the people who can seek address under DV Act, whereas respondents in section defined in section 2Q is not limited to women, but also not limited to adult male men, but also can be related to adult female women. This was the second case.
Thank
Whereas,
you for that. Thank you for the cases. That's actually really interesting. You can see the change over time. Parth, what's your point? Like,
Yeah, sorry, am I audible?
yes.
Yeah. I think what Arvind's the framework that he's put out is brilliant, but I would take a step back and look at how the framework developed through social movements. Like if you look at the supporting literary works prior to the 1983 amendment, which included Section 498A, it lays out a story about how from 1920 onwards, the social movements surrounding women's rights started. But they were primarily linked to the independence movement, the independence struggle, of how the liberation of the Indian woman is through liberation from the British. And that seemed very apt for that time. But once in 1947 we got independence, there's a lot of literature that shows how a lot of minority identities within the women subgroup were left out from reaping the fruits of their struggle. The women who were most empowered by the freedom struggle, were those from the upper economic classes and upper caste groups. So post 1947, women's movements died down. 1950s again, they started gaining relevance, and there was a lot of uproar regarding domestic violence and dowry death. They were the two primary causes that women's groups were protesting against. And 1983, as a result, the Section 498A was introduced in the IPC. 1986, 304B was introduced, and this was seen as a success in the start. But if you look at a lot of literature post 2000 and prior to the 2005 Act, it shows the abysmal rates of convictions in domestic violence cases and how systematically the legal provisions that were made to protect women were actually subverted. So interestingly, one of them is the Family Courts Act of 1986 itself. And what it did was it took jurisdiction for domestic violence cases from criminal courts to family courts. And as an aim of family courts, it's to preserve the family rather than uphold the rights of women. So there were these small nooks that were used systematically to remove and reduce the effect of 498A. And there's actually a very interesting study. It's by the Center for Social Research, Delhi, in 2005. They did an empirical analysis, and that uh, they concluded about the abysmal rates of convictions in 498A. So their conclusion was, out of the 100 cases which were ordered for investigation under 498A of the IPC, only in 2 cases did the accused get convicted. So out of every 100, only 2 convictions. Plus, what was more surprising was the convictions were only in cases where 498A was linked with 304B, that is dowry death. So prior to the 2005 Act, domestic violence, first of all, wasn't a term itself. It was under cruelty towards wives. And there was zero convictions based on, I have a statistical backing to say this. There was zero convictions under 498A alone. And it was only post the 2005 Act that a separate legislation was made because of these issues. Post 2000, there was a lot of protests again for a separate legislation for a definition of domestic violence, and that led to the 2005 Act. Yeah, so I wanted to lay out this framework prior to 2005. So yeah.
Thank you for that. That's actually very informative as well, especially the statistics of only 2 people being arrested is shocking. So this actually leads to the next question. So is this situation is the situation which is in India worse than it is in other countries, or would so I would like to discuss regarding a differentiation between what we see in India and what we see in other countries outside with regards to domestic violence and the way that this violence is dealt with. So does anybody have any comments regarding the same? I believe Ishita, yes, do go ahead. Ishita, I think her internet is stuck. Does anybody have any other, like anybody else have any comments? regarding this while Ishita is.
Yeah,
Yes.
I think regarding that issue, one thing that should be kept in mind is that there are a lot of studies that show how statistics and records are not a true reflection of the ground level reality. Like in India, I remember a similar example would be that post the 1980s change in legal provision regarding rape laws, the number of rape cases in India increased. So there was a little bit of debate around, oh, did stricter laws lead to uh, more of such events? And a lot of scholarly opinion actually said no. The cases didn't increase, the reporting of these cases increased. So domestic violence as an issue, just because say a developed country has lesser statistics than India, that doesn't mean that it's less there, and vice versa as well. I remember reading in India, domestic violence cases are still comparatively less as compared to developed countries. But that understanding is, we have to take it with caution, because reporting is also a very big issue in India, considering we are still dealing with even more, I would say, preceding issues like uh, female child mutilation. What is it called? Um, Female feticide. So yeah,
Infanticide, yeah, female infanticide.
yeah, infanticide, right?
Right, Arvind, would you like to add on to that?
So giving it a psychological perspective, uh, this though a vague assertion, like, so as we think about it psychologically, we are a what is that? Collective community, whereas Western countries usually fall around individualistic communities. They are taught and brought up in a way where they are self-reliant and much more self-serving. They'll not be dependent on people. So we are a communalized society. So we depend on families and we are dependent on each other. We live in joint families and things like that. So this way, again, as he said, though we should, though the statistic says otherwise, that Western societies are prone to much more domestic violence, it's my, again, not informed opinion, but I think because our women are much more domesticized and dependent on people, I feel the domestic violence would be much more prevalent in India. There is a much more probability of domestic violence here being more, especially given one thing is also the population is higher. Second thing, as a community, we are very dependent, and given that patriarchy is also involved, women are kept domesticized, and this way they cannot even escape such a thing. So I think that domestic violence is much more probable, like it's much more higher here, giving a psychological perspective to it.
I have a question to you, Arvind. So, are you saying that patriarchy is more prevalent in India than it is in any other country in the world?
No, I'm not saying patriarchy, that's common. Again, you cannot measure patriarchy per se. So, what I was trying to say is, given there are cultural differences such as a collectivist and individualistic society, women divorces are much more accessible as, how to say, as an option there. Here, women especially, are now developing slowly. A large part of population are still not educated and things like this, and we are very collect how to say dependent joint family systems.
So,
So if a woman feels like she's threatened, the first issue would be to go to their parents and not take a decision on their own, and especially given that we all are a part of system, they again put them back into the system.
so there's
So
an underreporting
psychologically,
because of that.
yeah. So
Okay,
I feel this is not informed by any research
right.
or something, but I feel this is fine.
Fair enough. But what would you like to add to that?
Yeah, just a response to your question to Arvind and his points. I mean, psychologically, if you think about it, in terms of reporting, of course, percentage of like domestic violence rates in India are higher than the states, for example. it's about 10% higher. Sorry, in the States, it's higher than India. But if you think about it psychologically, what um, say a victim goes through, I think we also need to give due regard to the surrounding legal provisions that empower women's rights or prioritize, I would say, more likely. If you look at the first examples that come to me are the marital rape laws, where the institution of marriage is put above the individual rights of female autonomy and in liberty. Secondly, so there are a lot of provisions like this. Even prior to 2005, there was the idea that, stemming from the fact that, say in property law, in terms of inheritance, the daughter does not get an equal share as the son, or does not have a birthright in the father in the family property. So there are a lot of surrounding laws that sort of give women the status of a secondary citizen. This is a terminology that's been used in a lot of minority identities. So psychologically, I think that also has an impact in uh, whether a victim believes that she has a right to justice, and that I think has a direct correlation with reporting of such crimes.
Thank you. That actually is very relevant. And now I would like to extend this a little further and ask the question, since women are seen or often seen as secondary citizens, or they're treated as secondary citizens, do they have access to the healthcare, both mental and physical, when especially after facing something like domestic violence? Is India equipped to provide such care to the women who have suffered with from domestic violence? Lavanshi.
Right. Yeah. So I think while we were discussing about the jurisprudence of how domestic violence as a law has evolved, so there we also identified that there are different implication of domestic violence. There are mental health, that sexual abuse, and physical violence. So there, I think, in India, there was a data that the reporting of physical abuse is more than mental abuse, and also we can correlate that to how our law has also been evolved, because mental cruelty as a law or as a provision was not recognized until, I guess, 2011 or 12, when these cases came up. And these cases were basically not isolated cases, but they were linked with dowry cases, as we also kind of made link between 498 and 304. So these mental cruelty cases were linked to the dowry cases, but as an isolated event of mental cruelty was not, I mean, I don't think so. I mean, I have read reports, so they were not recognized as such. And now, if we talk about reporting, so I think that is also dependent upon how the rehabilitation resources are also given to particular act or particular reporting. If the reporting is lesser, the parallel institution of providing help is also, I feel like, not that to that extent. As of now, I feel National Commission of Women, they do actively engage in domestic violence cases and also mental health in specific realm. And in this area, in this mental health services provision area, I feel the organization, the NGOs, have actively came up to provide help. Even if we look into the when I was searching about, what are the recourses a women can have, mostly there were NGOs helplines providing legal services or mental health counselor services, but I couldn't see any nationalized system which could aid them, which could aid women in that direction. So I feel that needs to be worked upon, because we, as we always see domestic violence as someone beating up, but not into the emotional aspect of it. So yeah.
That was
Also,
oh,
yeah,
sorry.
I'll add up on later. I'll add the later point. Yeah.
All right. Does anybody have anything to add on to this? Wait, you have something to add on to it, right, Luvanshi?
Yeah, but it's like a different aspect of it. Like how in COVID, like we discussed, the
Hmm.
cases have drastically increased, and the number and the cases were increased, although it were not shown in like reported cases, but there were, due to how we discussed, like, uh, limited accessibility, and the greater time spent within like partner and within the home, and also financial aspect of it. So I think in India we didn't really, although we I mean increase this helpline, or that person can approach these helplines. I think you can there was a system that you can call just 100, and you can record verbally the incident of domestic violence or anything we are going through, and that would be submitted to police facility, and they get back to you. So that was a system. But again, I read that there were many initiatives which were taken in different countries, like in I think Netherlands, Norway, United States. There was a coding messaging system. So since in like COVID, pharmacies and supermarkets were open, so they devised a system that there would be a code. So the staff of that pharmaceutical grocery store, anything, they were trained in a way, if there's a code which is given by a woman or a person to them, they will immediately take action. So even if your abuser is around you or in the same vicinity, you could relay that information through verbally or written message, just with using that code. So they use that, and it showed some successful result also. So I think that was very interesting to know that even in that circumstances where you couldn't really approach a person, the system really helped. So I think in India we couldn't really see such mechanism, but yeah, that was really interesting to know.
That is pretty interesting. I let's hope that India can implement a system like that. But now, considering the systems which are in place, at least in other countries, regarding domestic violence against women, do we believe that there's a gender disparity as to like, when it comes to domestic violence? Like, this is a conversation that came up a lot, especially after the Johnny Depp case. Like, a man be like, can a man face domestic violence as well? Can a man also be abused, or can the other gender also be abused? So what is your opinion about that? But please.
Yeah, so I think this question is very complex and it's very packed. There are a lot of layers in it. Couple of things we need to keep in mind is, in terms of gender, we look at it only in binary terms. Gender disparity, should the law be completely gender neutral? Should disregard gender as a whole? And in terms of its scope, both in terms of non just non heterosexual relationships, as in only should it govern only a man woman relationship, and two, should it only govern marital relationships. There's a recent case of the Supreme Court, not very recent, but I think 2013 or 15, where they recognized live-in couples as a domestic, um, what is it, domestic space or domestic relationship.
2018. Lalita Topa
2018.
was a state of Jharkhand.
Yeah, there was that Wire article, no? That reading.
Yeah, yeah.
Yeah, so they recognized a live-in relationship as a domestic space. Now, when I was reading about it, the person that came to my mind is, should the law be gender neutral? I think definitely. But what should the reason for that be? Should it be that um, men's rights are not upheld? Maybe. But I think more than that, what's important is for the law that what's more important is that the law should be gender neutral to give due regard, protection, and recognition to the variety of relationships that exist in our country right now, and do deserve protection, to be very honest. Now, interestingly, if you think about it, there's a question to my other panelists as well. There's a live-in relationship between two men. Now, technically, a live-in relationship has been
Yeah, yeah, sorry.
yeah. So this is also a question I posed to my other panelists as well. That if you think about it, a live-in relationship between two men, live-in relationships are recognized by the court as a domestic space. So in that space, do you think issues of domestic violence would arise? If they arise, would they be recognized by the court or the state, as in the enforcement agencies under 498A or the DV Act? It's interesting to think about it because that actually makes a very strong case for gender neutrality of the law rather than rather than thinking of it as taking care of the rights of both genders. We could think of it as a means to recognize and award protection to the various varieties of relationships that exist in our society and deserve protection. That is something that I thought was should be talked about more.
Absolutely, but that also means that the government would be supporting same-sex relationships, which is something which is a little ahead in time and not something that's
I mean,
us.
technically, the court is a part of the state, which is something that we forget. And when the court recognized same-sex relationships in Navteej Singh Johar, it was on behalf of the state. So they do recognize it. Whether the enforcement agencies actively protect it is
Hmm,
second is the
right.
second step.
We're getting there, which is the point, and that's
Hmm.
important. Arvind,
Yeah.
Yeah, again, about recognizing the thing. So we'll have to also think about severability of provisions here. So because DV Act as an act or legislations that help against domestic violence uh, are ingrained in many notions of patriarchy. So, for example, dowry as a practice is mostly towards women, directed towards women, and many other provisions such as domestic household and things are based on patriarchy being acted against women. So maybe, of course, recognizing such a man-to-man live-in relationship situation is good. But how would we do that is again a very complex question, isn't it? So can specific what is that conditions or rights against that can be claimed by men is only the specific rights can be availed or the entire provision is to be availed, and what are the complexities of that, what are the consequences of that, all these are to be thought out, right? I understand every types of gender and various range of relationships should be recognized, but again it becomes really complex about what to what extent, and because many, as I said, many of these legislations are based on patriarchal notions to act against them. So to what extent becomes again a confusing question. All these might be legal nuances that might be applicable here.
yes, of
Um, I
course.
just I just like to respond to one thing Arvind said. It's just food for thought. But this if you think about patriarchy as a concept, or as in if you I personally look at it as an institution that imposes certain restrictions on certain classes of citizens, and that is there. But one thing that mostly we miss in, especially in our scholarly discussions, is that it does impose certain duties on men as well. If you think about it, there are a lot of cases that, okay, in my internships I've read where men are contending domestic violence in terms of their inability to fulfill the duty imposed on them to say earn a livelihood. Domestic violence does include mental abuse and economic abuse. So the patriarchal duty that is put on men to earn a livelihood, they cannot sit at home, they cannot sit idle, they cannot make less than their wives. Those issues are also within the ambit of abuse and within the patriarchal setup. The thing is, we look at patriarchy only as restricting women and um, giving men everything, and which is true to a large extent. But there are certain duties that are imposed upon men as well, which can lead to forms of abuse. So there is that need to make the law gender neutral, even from a patriarchal lens. That is what I'm getting at. Yeah.
Red Lovanchi.
Yeah, right. A very interesting thing Parth mentioned about is economic abuse. So when, I think usually when we are studying, domestic violence or perceiving domestic violence, this is something, economic abuse is something which goes like under, under the rug. And usually people don't focus on that aspect because economic abuse doesn't relate to any emotional, mental, or physical thing. It is basically, since if two people are earning and there is a joint account and there are shared responsibility, shared financial responsibilities, so just a partner manipulating and controlling those assets or like account can put a form of abuse on the other person who's also earning. So and I don't see in this abuse any gender aspect to it, because there isn't, as Mahatpat mentioned, that there is a need to look that through a gender neutral lens, because both people could be working. Yes, the employment rate, as we will discuss further, of women is low in India. But even if we do assume that there are two people working and such type of abuse is taking place, how do we place it? How do we place it under the ambit of the legal provisions we have here? I don't think so. Those are enough. There are enough provisions to really protect a person against that abuse. Right.
Yeah, I would like to contribute something. So, uh, the practicality, like answering to path. So, of course, I too stand with gender neutralizing laws. But the problem here is that, again, as I said, practically, if we are thinking about gender neutrality in laws, it would dig the foundations of what we have built on. So most of our laws are binarily made and things like that. So again, as I said, these are based upon assumptions over assumptions. So we'll have to change the entire legislation, or for that matter, constitution in several aspects. So to what, like practically thinking, to what, till what extent can we be gender neutral is something like looking for a solution mentality rather than, of course, criticizing makes sense. That's how evolution happens. But going to the solution mentality, what would be the solution? How, to what extent should we change laws practically, and how would that have implications? That should be thought about, isn't it? Of course, while criticizing laws for not being gender neutral.
Um, okay, interesting point that you put out. And just one thing I'd like to shoot across before I respond. So if you look at the US again, now before I make this point, I'd like to clarify, I don't look at US as a representative sample for India. I only look at it because there the reporting numbers are higher. There's better tracking, there's better, of course, they have the limitations, of course, but we do look at them for a trend usually. And I say this with a lot of hesitation, but they do have a more developed, more proper, I would say, lower reporting systems, like the lower judiciary, the enforcement agencies. So if if you look at US, there's a statistics by their State Department which says that 28% men have felt, um, I don't want to go into the technicalities, but they have faced violence, domestic violence, in terms of stalking, harassment, or rape. So violence has a bigger ambit also. So only in terms of physical violence, 28% have faced it. Just that there are globally there are cases that are reported when the law is gender neutral. What Arvind said about changing the law practically, see, there are a plethora of ways in which it can be changed. And so there are two different things. One is changing the law on the books, and one is changing the enforcement of the law at the ground level. For example, some would argue Navtej Singh Johar changed the law on the books, but on the ground level, there are still a lot of biases and prejudices that same-sex couples face or LGBTQ community faces. So regarding the changing the books part, there are multiple ways. One is lobbying through the legislature. Second is the courts interpreting a particular provision as gender neutral. There are a lot of cases where an expansive interpretation is taken, which is quite contrary to the literal meaning. A man can be read as a man or woman. That's the general clauses act. There are a lot of interpretations like that. So the courts can intervene. There's a legislature to intervene. Um, Lobbying through uh, whatever activist groups. So there are ways to change the law regarding the low level enforcement. See, it's a long process, and of course, practicality is at the primary forefront of whatever conversations should be about. But if the goal, if the aim is correct, there are ways that will come up. There are a lot of um, reports made by the Ministry of Justice which talk about low level enforcement. There are directives issued to the state departments. The Supreme Court themselves issued directives to various police agencies, other enforcement agencies regarding their conduct with regard to these laws. There are sensitization workshops that are put in place. So there is a plethora of instruments present in the state machinery to implement these laws, provided the political will is there. And the political will be created through lobbying, through protest, through activism, which is we can see in 1980s how it led to the rise in how protests for women's rights led to change in law, and now we see at the ground level there is a significant rise in reporting. At least convictions were an issue till 2005, but over a trend, say 40 years, 1980 to today, there is, I mean, I would say, personally say, and there's a lot of scholarly opinion on this also, there is there's a large um, upliftment of the dignity of women's rights and how the institutions deal with it. The National Commission of Women has a plethora of powers to deal with any and all issues governing women's rights. So I do feel that practically also change is possible provided there's political will or judicial necessity. So you need either of the two. Yeah.
Novanshi, please add to that.
Yeah, on the subject of changing the black letter law, I feel the institutions that we have already we are placed in, and we have DV Act and other provisions and avenues for women, and changing that and making that gender neutral, for me it doesn't, I don't think it makes sense. But changing, as Path mentioned, other avenues for them, for people other than women, would actually, I think, will be fruitful. Because uh, we cannot leave the feminist argument unacknowledged here, where they I think validly pose that putting everyone under the same umbrella and making it gender neutral does somewhere undermine the century old oppression on women. Because the if we do see the trend, also we do see the statistics for other gender are bleak. I mean, I know on ground there must be like a more number of incidents, but if we do look at statistics, the key is inclined more towards women, and the oppression is more towards women. So I feel changing, when we're talking about changing the foundational legal instruments which we already have for women, should not be altered. But yes, through change can be brought up through case to case basis, and precedents can be set up. I think through that um, uh, channel, one can achieve the goal of gender neutrality.
Agreed. Right. So talking about gender neutrality and domestic violence, I would like to pose the final question for this roundtable, and that is and also this is a small extension towards the economic debate that we had earlier, which is, so the question is, if there's any correlation between domestic violence and female labor force participation, if domestic violence hinders the female labor force by increasing it or decreasing it in any way. So like, if anybody has any comments to add on that. Lovanshi, do you have anything to say to that?
Yes. So I think I was reading this study by Kalmas and Strauss. So they found that the unemployed married women. So it can go two way. I'll explain how this goes. So they found that the unemployed married women in the US are exposed to significantly higher risk of severe spousal violence. So that their because their bargaining power reduces and their financial independence, kind of they were more exposed to violence. But and wait, right. So that as I mentioned, that they lend support because bargaining power. But on the other hand, there was this other studies by John in 2020, that in the traditional setting of Nepal, married women engaged in paid employment face a significantly higher risk of intimate partner violence as compared to their unpaid or non-working counterparts. So these are two contrasting studies, and there is a difference in the cultural ethos of two countries, US and Nepal, where in US the unemployment actually increased the violence, and on in Nepal the good financial situation or financial standing also increased the violence. So what could be the underlying factors be leading to that, and what could be the rationale behind in Nepal where they more a good position of women in financial economic sense. So there the rationale was that this they gave it as a male backlash theory, which argues that women's employment provokes their partners to coercively control them so as to prevent them so as to prevent any perceived threat to a prevalent gender norms and hierarchy. So they are using their so if a partner has a higher standing financially, and to this perceived patriarchy setup, a men face a threat through a gender norm, so as to kind of I don't know, coerce them, manipulate them, and show their physical power against them. They would use violence as a way to feel more worthy, or or more like, I don't know how do I express this, like as a
Manly.
manly masculine, they wanted to feel like. So yeah, I think this question I would like to impose, like, what do you think, like these two contrasting pictures we have, and what can be the underlying, and how does legally it plays, how does economic plays a role in these two settings? And I think that can be a one prompt here. What do you guys think about it?
Arvind first, and then Path can continue.
Again, as she rightly pointed out, these two countries, Nepal and US, right? So they are culturally very, very different. So coming back to the old point again. So whereas Asian countries usually are family based, so there are much more obstacles for a woman who is earning. So when a woman is earning in this place, in US, for example, she would be seen as she has the ability and absence of obstacles via family and surrounding like societal things, which doesn't look down upon her, doesn't act as an obstacle upon her, because of course family, they are more individualistic and they accept women going into there. It's not looked down upon. So this doesn't act as an obstacle, but rather acts as an empowering tool there in US. Whereas in Nepal, such behaviors are looked down upon, and these family setups, and basically they act as a stigma basically. So this way, I think this is the root of this socially different attitudes towards women going into job is the root cause of this contradiction, is what I think. And of course what she said, like from an individualistic perspective, men have their own mental standards. Of course this attitude also spreads towards men. So this will be an individualistic perspective of men, whereas on a societal level, all these families and society, everything acts as an obstacle to them. This is the reason for contradiction, is what I feel.
Yeah, adding on to Arvind's point, he spoke exactly what I wanted to speak, but in a more detailed manner. So there is cultural context and there is institutional context. Both in both senses, in the states, for example, the individual woman is not stigmatized. In terms of institution, if I compare to India, if the debate around divorce is actually pretty prevalent right now, because no fault divorce is actually a very contested issue. The idea is, if you look at the divorce laws, either in the Hindu Marriage Act or the Muslim laws, or even the Special Marriage Act (SMA), which is religion neutral, there must be a cause for divorce. And no fault divorce is actually not a thing yet. So the idea is that marriage, if you've gotten into it, it's good, and you must have a reason. You must have fault for which to exit it, based on which you must exit it, either cruelty or otherwise. So whereas in the US, no fault divorce is actually permissible in most states. So institutionally, women liberty is sort of prioritized, and it's given more freedom to express. I think that's one of the reasons why. I mean, Arvind talked a lot about culture, but institutionally, women have support, and that is I think one reason why the domestic spousal violence rates would be less for working women in the states, because through their financial independence, they can avail these liberties that the U.S. institutions provide for their women. In Nepal, on the other hand, I don't think that would be the case. Comparing, I think Nepal and India would be comparable institutions, at least to, on a micro level, if not a at least on a macro level, if not a micro level. But I think that would be a very prominent reason for that. Yeah.
All right.
Yeah,
So, sorry, Lovanshi, you have something to add?
yeah, no, no, go on.
Please add if it would be.
No, no, yeah. So actually, what both Parth and Arvind pointed out, so cultural norms again do play a very prominent role when we are talking about the relationship between women, um, employment in workforce, and their correlation with what domestic violence. And I think we have to look for the pattern of labor market also, because if we're talking about agricultural activities in India, so I think there, to some extent, there have been studies that if the involvement of agricultural activity, because that is a form of employment, and the general notion about that a financial independent would might protect as a shield for you to not get abused. That was not true in agricultural activities, right? Because women were still, really much prone to abuse by their spouses. On the other hand, in urban or semi-urban areas, in non under the non-agricultural activity workforce, there were less. I won't say there were lesser cases, but yes, there was a hint that that statistics were not reflected there. So I think one, cultural norms and also pattern of workforce do depend, and it's really the nature of, yeah. So about the general labor market has to be looked upon as well. Right.
Yes, Paul.
Yeah. Just one thing. I think, just to sum up, regarding the question Lavanshi made, we need to also remember that institutional mechanisms and cultural contexts are not in isolation. They actually influence one another. When there's a change in cultural context, institutional change follows. Another thing that came to mind was, I remember in interstate succession in India right now, under the Hindu Succession Act, the wife's property, if she dies intestate, that is without a will, goes first to the husband, and then, if the husband is not there, to the husband's parents, and then to her own parents. So there are these small, small things within the institution currently that do hinder female autonomy and independence, even despite her financial independence. So there is that correlation there that must be given due regard.
Yes, Arvind.
Again, finally adding to this point, uh, I feel I might be pointed out as a conventionalist for this. So before there should be even Ambedkar recognized these kind of attitudes, but in the context of caste. So basically, Ambedkar recognized, given that before changing laws, we'll have to change the attitudes of the people. The counter argument might be made that laws influence attitudes towards people, but there are a ton of examples which suggest otherwise. For example, as the very instance that Path spoke about, let's take interstate laws, not interstate, what is it? Intestate laws. Yeah, when 2005 amendment was brought up in actually before 2005 amendment, where women were given rights to inherit father's property directly as a first head. Only males were given right. Before that, states had brought up such laws prior to that. But in Punjab, when Punjab as a state brought up such laws, a study was made which essentially sought killing of women when their partition was about to happen. The increase of murder of this age women just before the partition happened was noticed, which was an aftermath of this law. So what happened was there was a trend of higher rates of murders with respect to these women who asked for partition, or there were a trend where women had gifted their rights in the share to the male heirs after this law. So before a law can be implemented, at like a societal change of attitude ought to occur. That should be, as Path rightly pointed out, through lobbying, awareness making, all these things before laws should be put up in place. Same thing I would say with no fault marriages. Here, if we, as I said, we as culturally, we are a set of people who have been grown up in collective mentalities. We are grown up as families, so no fault marriages might have other unintended dire consequences. So before we change laws, are in need of recognizing the attitude of people and slowly changing the awareness that happens, attitude towards that problem. And sudden pushing of laws into people would have dire consequences such as this, which is much more worse than the problem that's prevalent now. So,
Yes,
Yeah.
Parth, let's make this the last
Yeah.
comment. And yeah.
Yeah. No, what Arvind said is actually pretty on point. And just to take that argument forth, what happens is if a law is brought in prior to social change, the example that Arvind took was very apt. And what happens further on is that the social change, the society resists and brings in subsequent institutional changes that hamper the original change. The
Hmm.
example being, so Arvind, I don't know if you did this in your family law classes. There's something called a relinquishment deed that the daughter or the mother can sign that, hey, I'm leaving my share in the family property by my will and everything. So that was brought in as a very big concept. And interestingly, I was doing a study on this and I saw for the state of Rajasthan, Gujarat, and Madhya Pradesh, a relinquishment deeds draft was present on the state website. They said that to ease of access to relinquishment deed, we are putting it on the state website, and there are drafts available in the regional language as well as English and Hindi. The idea being there's a sort of state endorsement that came, which
why
is
going that far? Why going that far?
uh-huh.
Even the tax rates for in most states, even the tax rates for relinquished deeds are much more lower than gift deeds. Gift deeds is basically the same thing. Settlement deeds and gift deeds are not very different, but gift deeds have
Hmm.
much more tax because gift deeds
Hmm.
can be done outside of the family, whereas within the
Hmm.
family the tax rates are much more lesser.
Hmm.
Like
I
most
mean,
states are like that.
no, that's a slightly contested point because tax rates for gift deeds within blood relations is next to zero.
Point I'm trying to make. So within like relinquishment deeds, the scope of relinquishment
Hmm.
deed is within families usually. You give your right, relinquish your right towards the family members. Well, gift, the scope of gift deed can extend to other members as well. So technically, what they're trying to imply is that if you're giving it to your family, especially women to men, why are tax rates low? What is the ratio behind it? What are you trying to do there?
Right. Fair
So
point. Okay.
let's end this conversation at that question because it's a very big question. So thank you for this discussion. It was actually very interesting and very fruitful at the end of it. Like it was very engaging. So thank you for the discussions. And we learned how things need to be changed, how things need to be made gender neutral, and about how even though the laws are progressing, there are certain aspects of it which are not. Even though the society is progressing, there's certain aspects of law which still need to change, just like our discussion that just ended. So thank you for this roundtable. It was very fruitful. Thank you for participating.